I was going to ask Councilman Purkeypile, who had the opportunity to visit with the principal of Marble Flats on that property, if you would give us a brief update. I think it would be appropriate now.
Okay. Well, I'm not going to answer. I'm not speaking in any way for them.
Right.
This is not, briefly, I've been on the property with the Brickses, been on their property, and been on the property at the invitation of Marble Flats. And we went to look with the contractor to discuss the viability of using that as a street, and in particular for easement access. Contractor did indicate, there is an old road that connects to this. It goes up and winds up to the top of Marble Flats. It's an old, it's still improved, it's still usable right now. However, it hasn't been used in some time. I did ask them, Marble Flats, and I'm not speaking for your client, sir, did ask them if they would consider if they obtained an easement for utilities, because my impression is that they probably agree with me that it's not a good access point for vehicles. But that's not to say for service or utility vehicles upon occasion. In particular, my impression was that they wanted it mainly for utilities easement, because it was just, mainly for sewage, since we have gravity flow. It'd be cheaper to have that access down. So, and once again, gentlemen, I hope I'm not stepping on your toes or anybody's toes here, but that is the gist of my conversation with them. And so that's why I asked at this table that some sort of compromise, and I actually put forward this concept here, which has resulted in the second draft ordinance that has been provided by the Bricks' lawyer.
Mr. Mitchell, going to
continue with that then. And so at this point, we are discussing vacating, which has to do that we have already, the city has already reclaimed the Rock Street, and we're now looking at vacating to the Brickses at this point in time. So we have an ordinance before us, it looks like the second one here, which has subject, it goes everything, and then the last paragraph says, subject to an easement for the purpose of underground utilities granted to the city of Eureka Springs or its assigns by Ryan and Rachel Bricks with a width of 10 feet from the western border of said unnamed street and running the length of the eastern side of lots 1, 2, and 3 of Block 2 of the aforementioned plat. Any underground utilities installed in the easement area shall be fully encased in concrete or steel sleeves, and any construction or maintenance performed within the easement area shall be performed in such a manner as to result in minimal intrusion to the surface land, and all surface land shall be restored to its previous condition upon completion of such installations or maintenance of the utilities. And Mr. Purkeypile, from your standpoint as an engineer and what you discussed with one of the principals, then that met what you thought that principal was saying?
Yes. Let me be clear. I'm not speaking for them.
I understand.
They did not agree that would be all that they would want. It's something that I posited. It's something that I brought forward for them to consider. And I would have to say that even then, putting utilities, you're going to have to bury them, which means rock cutting. Can't blast in the city limits necessarily, but it'd be rock cutting, be extremely expensive. And I think that's what's driving all of this, is expensive of any kind of road and any kind of easement. So, but I just want to be clear that what I just said at this table are not the words of Marble Flats. That's just my discussion with them.
Continue my conversation.
Ms. Schneider, I'll get to you in a minute. Okay.
Mrs. Briggs, Attorney Matt, may I ask you a question?
Sir, let me get up to the mic.
Yeah.
Please, sir.
Yes, sir.
The section I just read, at some point in time in the past, did you propose something similar to that to the Marble Flats or their attorney?
I don't know that we've ever gotten to the point of writing something down. We've had discussions
Verbal.
along those lines. Yes, sir.
And what was the response?
I don't know if you want me sharing that at this point. I mean, I think negotiations are more effective when they're not public, if that makes any sense. But I just say the first response I heard to that was last time we were here, and Mr. Williams indicated his opinion.
Okay,
Ms. Zeller.
thank you.
I have a question.
Is this for Mr. Bishop, or is this just a question in general?
Yeah,
Yes, ma'am.
is it true then that if Rock Street were vacated and it was not available as a road to Marble Flats, then is it true that there is no other possible entrance to Marble Flats, and those lots that are subdivided there would be forever landlocked, and the owners of those lots would never be able to get to them any other way except up Rock Street, which is what I understood Mr. Williams saying earlier tonight?
That's what I understood him saying as well. I'm not sure what lots he's talking about, but as I recall, Marble Flats has access further up, further to the east and further to the south. And it's all contiguous. So I'm not sure what lots he's talking about, but my recollection is there's access at several other different points.
I thought I saw when I was there, although I could have been hallucinating, but I thought I saw a road that went into that area.
I believe I see Ms. Schneider with a plat there.
Yeah.
I don't know if it shows
There is, but
which all the property that Marble Flats own, but I don't recall them being landlocked.
But yes, there's another access point. It's an improved road with a gate.
so it's
And
not
got-
true that they would be landlocked and
I don't think
would
Mr.
be
Williams
forever
was referring
forbidden
to-
access. Okay.
I don't think it's referring to the Marble Flats property. It's referring to other
Referring to
unvacated
city lots.
behind,
City owns.
just west of the Rock Street.
Oh,
Okay.
city-owned lots,
Yeah.
which we, okay,
Just a minute, Mr. DeVito?
which
would
are
you
going to be
please turn this
trails
to Mr.
anyhow
I
or
will
something.
for a
broach
little
if I
bit,
ever get a chance.
Talking a little stale in here. All right, Mr. Schneider.
Okay.
Tired of this whole subject.
I don't know if we can see this or not. I got tax papers, property tax paper type stuff. I have a whole stack here. If y'all want copies, somebody will do it later. Okay. If Rock Street is closed off, the landlock that I believe was mentioned will be from this point right here. This is where they want to stop. All of this property here, this road will be effectively ended. We have Main Street here. There are 4 properties owned by Maria Carstens, and I've talked to her. She's in Fayetteville right now. I've talked to her. There is 15 city lots. Without Rock Street, there's no access. I have walked it very hard. I've been through the Marble Flats. I've been through the bricks. I honest to God, do not know how we can settle this, but there is no access here. And 15 of those are ours that we can't do anything with because there's no access. 4 of them are Maria's.
I'm sorry.
What is this down here?
Okay, see, this is all part of Rock
I
Street.
know, but is this a street and it comes in here and goes
Okay,
past here?
here's no. If you cut off Rock Street, this green line goes away.
But isn't that an access to this part here?
Here's Main Street. This is Mill Hollow. Not if you cut it off.
Well, that's not what we're talking about. We're only talking about that piece that goes up through the bricks property.
This is Rock Street.
No, they're not proposing to vacate all of Rock Street. They're proposing only to vacate that northernmost part that goes through their
No,
property.
not all of the
Okay,
street.
so they're up here, and this is Rock Street.
And then
We're only talking about this little
Zeller
piece down here.
Pointing out, you would continue on there. You can follow
Yeah, this is all Rock
and
Street.
keep going down, keep going, and you hit other public streets right there.
Where is it cutting off right here?
From there.
Right there?
north. Yes.
Okay, so if you have it here, even if you get all the way up in here, this is the only to and from, and that's a hell of a long way.
True, but you're not. I don't know how far it is. But you're not landlocked. You have a road to it. In fact, you're adjacent to it.
Okay, like I said, I walked it. The other problem that arises with this, and right now, like I said, I'm looking at all kinds of different things. The other thing is, there is a law, and I don't remember what it's called, but we ran into it when we were talking about the McCune-Hartman thing. If you take away any ingress egress from a property owner, it's illegal. Does that include this, Mr. Tim?
As it now stands, if you even though Marble Flats and or these other lots may have other access, if a court concludes that that is access, and it appears to be access on everything on all the plats, if that is access, then yes, you are removing access, and the courts in Arkansas have held, even though there's other access, you are liable to the damage by jury verdict of how much that access that you cut off is worth. It might be worth $1, it might be worth $1 million. It's up to 12 good people selected from this county.
Well, because when that came up with the Hartman-McCune thing, that sent off little red flags, because we couldn't vacate the section because it cut off access to two property owners. So what are we doing here if we've got 15 and she's got 4?
You're not cutting off access because you continue to have a public street,
We are
and
cutting
I
off
believe,
access.
and I believe
let him-
that only
hold on,
applies
just let him
the
finish.
case that Mr. And I know Mr. Williams will disagree with me. The case that Mr. Weaver is discussing refers to abutting property owners, not any property owner. And the part that you're vacating doesn't abut any of those streets
Okay.
or any of those lots you're referring to.
If all these properties are here, and from this point on, this is taken away from all of these properties.
They do not
that's
abut. That's where she's seeking to vacate.
Where we had the McCune-Hartman thing did not abut.
I don't know you're talking about something I don't know anything about.
Well, this is something I've run into over the
I
years.
didn't have any problem with
Okay.
McHugh-Hartman.
Mr. DeVito, got your hand up next.
I make a motion to assign this ordinance, and I'm referring to the document that at the bottom has subject to an easement, assigning this ordinance a number and placing on its first reading.
Second.
Any further discussion on it? Mr. McClung, your turn.
Okay.
Yeah,
Wait.
He said any further discussion?
I would
Which one? The
like to say that,
It's a long one.
if arrangement could be made where, we do this with the easement, it's best with a water line. If at some point, it's a real potential growth place for Eureka Springs. At some point, where somebody will build up there. I mean, we don't have much left where you can that has any access to it. So if the sewer is very important as well as water, and water is best served when it's looped. So if a water line is run through there, then this avenue, along with sewer, would be a good position for a water line to loop back through as well. So I think it takes more than 10 feet, because I think you have to have a distance between a water and a sewer line, specific minimum. And so I think if an easement is to be retained, if that is the route that is taken, that it should at least allow for an easement wide enough to cover water and sewer. I'm not exactly sure what that is, but I think it's 20 feet, but that's not an absolute. I'm not positive.
I don't think it's that wide, but let's look it up, definitely. Let's be sure.
I'd rather see compromise always, especially since fellow members don't want to have a legal opinion given. Wade, is this a compromise? Is this basically the compromise you were
Wade, come
talking
up to-
about?
Number to Mac.
Or is this separate?
this is the first I've seen of the ordinances. They weren't sent to me ahead of time.
Do you want to?
As far as the compromise, it's something that I'd have to visit with my clients about.
What was it that you offered?
What I offered was that if everything was withdrawn, that we would find a place for trails, because the only thing I'd ever heard previously was that there was a concern about the trails going in front of their house.
Okay.
So we were looking for a way to resolve that problem,
Okay. So
and we
you had
made a
nothing to
proposal.
do
We
with
made a
an
proposal to do
easement.
it.
Okay.
So that was. I have not seen that. It's something I'll certainly visit with my clients about tomorrow. I'm a little concerned that there's a lot of what sounded like fairly specific engineering that's been written into an ordinance that I really doubt that your building inspector or anyone else is taking a look at for purposes of compliance with the building codes. And I'd sure hate to agree to a compromise that effectively resulted in the inability to use it for even the purposes for which it states it's to be used. So certainly would be something that would need to be reviewed and looked at. These copies
Thank you for that clarification. To continue on with that, since we have one proposal, my ignored proposal, could we try to get a meeting of everybody involved, both parties, both lawyers, and the council, workshop, whatever you want to call it, to try to hammer out something before we turn this into a vacation ordinance?
So you've got a motion and a second on the table, so you're...
But I'm asking, can we do that? I mean, if all parties would be agreeable, of course.
Make it an ordinance first and
nobody-
then
okay.
discuss it.
Never mind, I'll
Okay,
withdraw that question.
Mr. Mitchell, let's go with you first.
I'll withdraw mine because she withdrew that
Okay, Mr.
interesting
McClung.
comment.
Which one?
Yeah, I think that really that this thing has been long and hard. And I think if there is a possibility of compromise right here, that it really needs to be, the city can do whatever it chooses to do as far as the vacation goes, however the vote goes. However, if there is some area for agreement here on some middle ground, I would really like to see that taken. To delay a little bit longer may be the right way to go.
Mr. DeVito.
We're a little bit out of order as far as our discussion. It should occur on approval of the motion, not on asking it to be placed on its first reading. We've got 6 weeks that, if we want to hammer something out, we can go do it over that point in time. But as has been pointed out, this has been going on for close to a year. And, I'm encouraged to place this on its first reading and deal with these on the subsequent readings.
Mr. Mitchell.
I ditto what Mr.
That
DeVito
has a
said,
second,
and I
doesn't it?
think since we have two attorneys here, after we'll see where this first vote goes, but I suspect there might be some negotiating going on in there. As Matt said, there'll be some attorney negotiating going on, and we'll just leave that with the attorneys and the principals involved.
Mr. Purkeypile.
I withdraw mine, I think.
Okay. All right. If the
I'm
clerk,
sorry, I didn't understand.
he withdrew his.
I withdraw.
Yeah.
What did you withdraw?
I don't have anything to say.
Oh, I see,
yeah,
okay. And
Okay.
earlier, I need some clarification because David also used the word withdraw, and I'm wondering if you meant your second for the motion.
No, I didn't withdraw my second.
Got it, thank you.
He was about to make another
I see.
comment,
Okay.
then we do.
Thank
Okay.
you.
All right, if the clerk will reread the motion for clarity and on the record.
Mr. DeVito made a motion to assign an ordinance number to the version with the easement included, and Mr. Mitchell seconded.
And there was a second by Mr. Mitchell.
Placed on the first reading.
And was there a suspension of the rules for this one? I didn't hear a suspension.
No.
No.
Okay, all in favor, say aye.
Aye.
Any opposed?
No.
4-2.
Okay, 4-2.
There you go.
Schneider and Terry.
All right, stand by for a number.
Motion to pass.
The ordinance number will be 2211.
211.
James, did you say the extended one?
Yes.
An ordinance vacating an unnamed, unopened street located between blocks 1 and 2 of the Magnetic Bay Survey as platted on the Riley and Armstrong plat of 1893, Carroll County, Arkansas. Whereas the City Council of Eureka Springs, Arkansas has reviewed the petition of Ryan and Rachel Bricks to vacate certain real property within the city pursuant to Arkansas Code annotated section 1454-104, and whereas on May 12th, 2014, the City of Eureka Springs reclaimed said area from the Parks and Recreation Department, and whereas the above described area is no longer needed for corporate purposes and has not been utilized for corporate purposes, and a proper petition to vacate has been filed, notice provided as required by law, and is before the City Council. Now therefore be it ordained by the City Council of Eureka Springs, Arkansas, that the following described lands are hereby vacated by the City of Eureka Springs, and title is vested in the adjoining landowners. An unnamed 30-foot wide street beginning at the southeastern corner of Lot 3, Block 2, and traveling east in a straight line to the southwestern corner of Lot 19 of Block 1, thence traveling in a northerly direction along the eastern border of said unnamed street, and ending at the northernmost point of Lot 15 of Block 1, thence traveling west in a straight line to the northeastern corner of Lot 1, Block 2, thence traveling south along the western border of said unnamed street to the point of beginning, all in Magnetic Bay Survey, as platted on the Riley and Armstrong plat of 1893, situated in the northwest quarter of the southeast quarter of Section 10, Township 20, Range 26, in Carroll County, Arkansas, subject to an easement for the purpose of underground utilities granted to the City of Eureka Springs or its assigns by Ryan and Rachel Bricks with a width of 10 feet from the western border of said unnamed street and running the length of the eastern side of lots 1, 2, and 3 of Block 2 of the aforementioned plat. Any underground utilities installed in the easement area shall be fully encased in concrete or steel sleeves, and any construction or maintenance performed within the easement area shall be performed in such a manner as to result in minimal intrusion to the surface land, and all surface land shall be restored to its previous condition upon completion of such installation or maintenance of the utilities thereunder.
Mr. DeVito.
Move to approve ordinance 2211 on its first reading.
Second.
Mr. McClung.
I think it would be better served if the subject to, if it read that it's an easement to the city of Eureka Springs is retaining that easement. It's not giving the property to them and then having them give the easement back. The city is just retaining an easement in the property. So the wording is more correct in that fashion, that you're deeding the property to them and at the same time retaining an easement for utilities.
Would it be moving the easement?
Yeah, let's ask Mr. Weaver, He has some of that.
That was what I wanted to call to your attention. Your whereas is basically vacating it, saying there's no purpose whatsoever, and then you're trying to take back an easement. The language doesn't match, just as Mr. McClung is pointing out to you. It needs to state that you're not vacating the entire property if that's not your intent. Because what you're doing is trying to give something and then say, well, we're taking this back. And then,
He's up here.
where Mr. Bishop went, he may have a claim of action against you for taking from the bricks. And even though he wrote the document.
I would disagree with that in the sense that Bricks should give another document. The only thing I would say about you raised a good point, but I think that the original easement is for ingress and egress only. I don't know that it provides for utilities, and so I think that you are clarifying exactly what it is. I don't think your streets provide or underground easements.
Mr. McClung?
You could be right on that, but historically, they've always been used for utilities.
I drafted that way to be very clear on what you were getting, and that way there's no doubt that what you're getting. If you wanted to add an amendment that they would execute a separate document you could record in the county stating that, then you would have no question about it taking, because they would have signed it and consented to it.
Why not just have a simple document where we deed the property over and retain
Because I don't know that you have that underground street. I think you just
Pardon me?
I don't know that you have the underground rights. I think you just have ingress and egress.
Mr. Mitchell?
Since this is just the first reading, I would hope that there will be some further negotiating, and now since the attorneys are still involved and the question's been raised, they have an opportunity to give us feedback to make any additions to this. And we've got 4 more weeks. I think the points are good and they're well taken, and I'm sure Mr. Bishop and Wade Williams will work this out in the best interest of all parties.
Ms. Schneider?
Okay, I'm really confused on one part. Way back when all this started, it was Rock Street, and that's how it was on the maps. Now it's an unnamed street. How did we get there from it's ours, and here's the name, and it's not, and here's not the name, and I'm so confused on this.
It's never been a street officially.
Those are the maps, Rock Street, right there. That's what
That
we
was just the surveyors.
Who are you asking the question to?
Of whomever can answer it. I'm confused. How to go from Rock Street to unnamed?
Okay, Ms. Briggs, can you answer?
Somebody? I got lost somewhere.
Way back when I filed my petition to vacate last February, it was being called Rock Street because that's what was on the survey. And I've presented all this information before, so I'll be brief in repeating it. Even the surveyor, when my husband and I met with him for an hour over coffee, admitted that based on all that information that I had brought to you folks in August, that he doesn't have any idea if it's Rock Street or not, and he doesn't even think it is. I went to the state surveyor, Everett Rowland, of the state of Arkansas. I've gone to several other people. I've pulled up several other documents, Ordinance 91, yada, yada. I presented all that information. Because this has taken so long and I've done so much research, there is nothing at all besides that survey that he even wrote a letter that I have that he says he assumed that it was part of it. The section line, the lack of dash lines, the different subdivisions, I mean, it just does not, there's no indication anywhere in any documents I could find that it's Rock Street, except that survey.
But it's definitely some kind of a city easement. That was determined, then that's what you're saying?
I'm just answering your question about whether or not it was Rock Street.
Oh, yeah, because I got really confused how it went from one to the other.
Yeah, and there are a lot of unnamed streets. If you look at the whole plat itself, there's a lot of streets. Like, for example, this street right across from our driveway is unnamed. There are several around the entire town that don't have names on them. So.
Right. That part didn't.
Yeah.
It's going from one to the other.
It was going from one to the other, and I understand that, and
Okay.
Okay,
Thanks, Rachel.
Ms. Zeller?
Does this, sometimes when we read these legal descriptions, they have the length also. We have a 30-foot wide street. Is there somewhere that we should be putting the length of this piece of land that we're considering also? I mean, it's 30 feet wide, but it has a definite length. We're not doing all of Rock Street. We're only doing that part that goes from the bottom to the top of the hill. Shouldn't that length be also in this description?
So doesn't that cover when they talk about the blocks, that it's giving it a distinct start and stop point?
But usually, like I'll say, a distance of 120 feet or a distance of something like that, it isn't in here, and I just wondered whether we needed to put
Maybe that's when it's a part of the block.
the actual dimensions of the piece of land we're considering is 30 feet wide, but how long is it, is my question.
Mr. McClung?
Yeah, all that's required is that the legal description closes and is correct. So it's all right.
Okay. just trying to get this right the first time.
Mr. Mitchell.
So we have a motion and a second. Could the clerk reread the motion?
To approve on
please?
the first reading?
All in favor, say aye.
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 Any opposed?
No.
4-2?
Vote two.
I want
We
a
have a
legal,
5-minute recess.
10.
All in favor, say
Second.
aye.
10.
Aye.
5 minutes.
Any opposed?
Aye.
All in favor, go.
I have too many legal opinions already.
During the day.
We're back in session. Brings us to number 2 on new business, which is a discussion of notice for scheduled water shutdowns. Motion to discuss.
We want to drop.
Motion to not discuss.
Motion to not discuss.
Second.
Okay.
We
All in
don't
favor,
want to
say aye.
discuss that?
Aye.
Okay, it's off. Is this a bring back or off completely?
Off completely.
Hold it.
Thank you.
Oh, you're just deleting it?
Yes, sir.
Good.
Well, we're not, okay. No, wait, we're not going to shut down the water?
Oh, no, that was a totally different cast history.
Don, do you need a second? You good, Don? I'm good. Okay, all right. Brings us to number 3, discussion of taxi ordinance. Motion to discuss.
Okay,
You get a motion?
I guess we need a motion.
Need a-
Can somebody make,
Give
can I
us a
make a
second.
motion to discuss?
Oh, second?
Okay, I make a motion to discuss.
I'll second.
Okay. Floor is
Okay. What I have, are we in business, or are we on?
Yes.
Or we're, okay. Okay, what I gave you was what we have, even though this was left out of the code book, it apparently, there's a difference of opinion as to whether it's enforced, and I don't think it matters or not. The problem is that we do not have an ordinance that really deals with who can operate a taxi cab in the city. We do not have a taxi cab franchise ordinance. We have never had one. And we seem to, well, the reason I brought this up is I'm trying to avoid legal problems in the future. Now, we already have this Mr. Dotson person who has taken us to court because he seems to feel that he has a license that empowers him to run whatever it is, and I can't even address it because I don't know. It's under litigation. But what I'm trying to do is get ahead of the curve here. What we need is an ordinance that describes taxi cabs, defends them because we have, or describes them because we have several different kinds. We have jumbo cabs and we have little cabs and we have limousines. And then I think we need a franchise ordinance that gives us 2 franchises because we have 2 taxi cab companies. And we need an ordinance that says that we have franchises and no one else can operate. Very similar to what we have with our horse and carriage and with our tour franchise. If we have a taxi franchise and we have 2 franchises and they belong to 2 different companies and they have the right to operate taxis within the city of Eureka Springs. It should enable us to avoid legal problems of rogue people who have a car with 4 wheels on it and have the ability to make a magnetic sign that says taxi cab and stick it on the side of their cab of their car and come into town on a weekend and solicit business. And I think I think the police need something that gives them the authority to say, I'm sorry, you cannot do this, you do not have a license, you do not have we have an ordinance, you do not have a franchise, and you cannot operate within the city, and it should be a fine-only regulation, and the fine should be at least substantial enough so that it makes it not profitable to operate a taxi. And the reason I gave you this is this shows you what we have already. And the little thing sitting here, this little piece of paper here, is from an email that was sent to me by the man who owns the taxi company, Abundant Taxis, and he suggested a definition of what a taxi should be, transportation of passengers. Now, I'm not about to get onto a committee to write a thing like this. What I would like is a motion to direct the city attorney to write a taxi franchise ordinance, giving us 2 franchises, making it legal, defining taxi cabs as we know them, and the rest of what I have here is everything that the state of Arkansas has on taxi cabs. This was taken out of the Arkansas Municipal League book that we get, and this is all that there is really on taxis, except that it's against the law for anybody under the age of 18 to operate a taxi cab. But this is all there is that the state of Arkansas has, so we pretty much have the ability, apparently, to regulate the operation of taxi cabs from the city. And that's why I'm bringing this up, because I'd like us to proceed tonight to begin the process of getting a franchise ordinance and getting it on the books so we can avoid court cases and legal expenses and legal fees and all that sort of thing, which I think if business picks up, and who knows, it doesn't look too good out there so far, but it was a pretty good weekend. If business picks up, we're going to have a lot of people coming into town here trying to poach on our taxi cab business, because it's a really quick way to make $200 or $300 a night and get in and out of town before you get arrested doing it. And we really need some legal oversight here. So that is my presentation, and what I would really like is a motion to direct the attorney to write an ordinance giving us a taxi cab franchise.
Clerk has a comment.
At the beginning of your term, there was a tremendous amount of information provided in a packet with all the previous ordinances and codes, and the last time the word taxi franchise was in a code book in this town was 1979. Mm-hmm. And all that verbiage still exists. Mm-hmm. And in all the reading that was done between that code book and this code book, there was never any trail of proper form, proper procedure for eliminating the taxi franchise. And Matt Bishop got up and explained that very thing. And so in actuality, you do have a taxi franchise. The language was taken out of code, but if you were to go back and look at the language in 1979, everything that you're proposing has already been done. It would just...
Okay, well this that I gave you tonight refers to that. This was taken out of the 2005 code book. This is the last time that anything about taxi cabs ever appeared in a code book. And you'll notice that they're...
That the language of franchise is not in 05. It's in...
No, but it refers. It says taxi cab operators. It refers to the 1978 ordinance. You'll notice references as you read this. It refers to the 1978 ordinance. So we apparently do have something. It obviously needs updating because there weren't jumbo taxi cabs back then, and we didn't have people with something that looked like an outhouse on wheels driving around selling tickets to ride in it and that sort of thing. So we obviously need something new. Now, whether we are amending what existed in 1978 or simply adding to this, I don't know, because I'm not a lawyer and I'm not even going to try to get into it. But we need to do something, and I would like to direct the city attorney to do what he thinks we need to do to bring us up to date and get us ahead of the curve on this before we get into any more legal lawsuits.
Ms. Schneider.
I thought we did have a franchise for taxis.
Apparently, we did back in 1978.
No. I mean, like when we did Abundant, wasn't that a franchise that we approved? No. Okay, they did a certificate of public convenience. Was that not for the approval of a franchise? Okay. And I'm asking her.
The language concerning certificate of public convenience and necessity is still there. Mm-hmm. Okay, franchise is more than that. It's much more precise, and the idea being that if you have a franchise, and I'm just going to choose this randomly, SWEPCO. If you were unhappy with SWEPCO's service, there's a process for sitting down with your franchisee and saying, we have these problems, can we solve them? If the franchisee cannot, then you move on to the next plan. But you don't launch out and invite another electric company in because you don't like SWEPCO, which is what Mr. Bishop was trying to convey. That the language of franchise for a taxi was never correctly removed from code. It was simply taken out of code. So the certificate of public convenience and necessity is still in play, and both Abundant and EUREKA Taxi have that on their business licenses. The language for franchise is missing. The proper procedures involving franchise has not been followed, and that's
okay. So I
put back in.
And that's what gets confusing: is the franchise, is it there, is it not? We've had this discussion for years. Okay.
To save some time tonight, could we postpone this till the next meeting and get the pertinent information collected in one place so that we can see what we have and what we're missing? Because right now, without all the pertinent documents, we're just going to redo something we've already done.
I'm not sure there are any other pertinent documents, are
Mr.
there?
Mitchell.
And to add to Mr. DeVito, could we ask that our city attorney give us that presentation so that we have it legally laid out for us to save us some time?
Mr. McClung.
We
But you
went
guys
through all
put
this
together.
back when we did the abundant taxi service.
That's what I thought.
Every bit of it.
I thought we did.
That was a long, drawn-out deal in itself, and now let's just open it all up again. You know, if somebody wants to buy a taxi license, they got to come before us to do it. Nobody's done it. What's the big deal? If somebody's doing it illegally, then it's up to our enforcement agency, the police department, to fine them.
We cannot legally say now that, no, you cannot have a
Yes, you
taxi
can.
company.
They don't have a license.
Yeah, you have to have a certificate of necessity.
Well, as long as they have that.
They
Yeah.
can't get that
And
except
they have
from
to
the
Okay,
get
state.
here.
slow down. Everybody's talking at one time. Mr. McClung still got the floor.
They can only get that certificate right here. We've not done any but two. So those are the only ones that can legally operate. That's it.
Then why are we in court with Mr. Dotson?
Whole different argument.
Yeah.
Whole different
Okay, and now how do we avoid having that argument with anybody else who wants to come in? There are going to be lots of people who want to come in here and start up their own little business, and we're going to end up with no taxi cab company at all because nobody can make any money. I mean, what we have now is working, and we should at least make some sort of an effort to preserve it.
Mr. Mitchell.
I guess what Mr. Plum says makes sense, and it sounded like the attorney was agreeing with him. So I guess we can get a statement from the attorney. Do we have now on the books the necessary guidance to limit the taxi service in this town to the two that we gave the certificates of whatever to?
necessity.
Necessity to?
I have not been made aware of any problems that exist. Other than we do have the lawsuit over the motorized quote unquote, according to them, carriage, according to the city, car. But that's not an argument over whether that's a taxi or not. They're arguing over whether it is more of a tour business, not a taxi business.
There's also a franchise.
They're not soliciting a different way. They're different. They're much as you argued about limos a few months ago. Their limos are different.
Well, we have a tour franchise, though.
They don't have a permit.
There was an incident on White Street where a gentleman who turned out didn't even have a license to be driving was soliciting fares, and I think the police probably took care of that eventually. That's resolved.
I can't speak for the police why they would or would not, but under this, that would be an illegal act if he was soliciting fares
I think they
as a
took care
taxi.
of it. Thank you.
The incident you're talking about is waiting to appear in court. Yes, he was breaking the law. Yes, they are dealing with it. They have been dealing with it, but we have to wait for it to show up in court. Now, the one little sticky part is a non-taxi driver person, whatever you want to call it, cannot put a taxi sign on their car. They cannot say it'll cost you $5 to go 2 miles. They can, unfortunately, ask for gas money. That is a sticky problem. It's something we might want to think about in regards to this. Right now, that's the only real problem, is superseding that kind of situation.
Mr. Purkeypile.
This seems to be something that we're kind of spinning our wheels in the mud here. Anybody that wants to have an operated taxi cab in this city has to come before this table and show a certificate of public convenience. And if they haven't done that, then they are breaking the law as it stipulates. And I think this whole concept of whether this is or is not a franchise, that's a whole different thing. I think we're covered, Ms. Zeller, regarding your concerns of other people coming in here and skimming off the top, so to speak. I think we're covered there. And that's where our police department would come in and issue citations and discourage that activity. And if I may, isn't that correct, Mayor?
Yes, it is.
Okay.
Any further? Is there a motion on the table?
No.
No motion on the table. All right. If no motion is on the table, we'll move on to number 4. This will be a summary of a workshop on the water sewer rates.
Motion to discuss.
Second.
Floor is open. Mr. Mitchell.
I see we have an ordinance here that pretty well sums up our workshop, it looks like.
Yes,
if
sir.
I read it correctly. So
The
without further ado, I'd like to make a motion that we assign this ordinance a number and have its first reading and get us going.
Second?
all in favor, say aye.
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 Oh, aye. Aye.
That was pathetic.
Is that this one?
Yes, it is correct.
Yeah. That was a pathetic aye, but we're kind of done.
The ordinance number will be 2212. An ordinance for the purchase and installation of water meters for the public water system of the city of Eureka Springs, Arkansas. Whereas the city of Eureka Springs, Arkansas, the city, is currently experiencing an undesirable amount of unaccounted water loss, and the city is committed to improving its infrastructure while maintaining reasonable rates and fees. And whereas the Director of Public Works has determined that a large portion of the city's water loss is from water meters either worn out or improperly installed by size and type, and whereas the Mayor and Director of Finance have verified that the funding is available and that the replacement of water meters is prudent and necessary, and whereas the resulting increased revenues shall be for the sole purpose of maintaining and repairing the water distribution system, which will allow the city to continue to provide their customers with high quality, efficient, and reliable water service in a manner that maintains the resources entrusted to its care. Now, therefore, be it hereby ordained by the City Council of the City of Eureka Springs, Arkansas. The City Council for the City of Eureka Springs, Arkansas shall fund this project with $152,000 from water and sewer improvements and $325,000 from general capital certificate account in 2 stages. Phase 1 shall replace insufficient meters 1 inch and greater, while Phase 2 shall consist of the remaining insufficient smaller meters. Section 2. The Director of Public Works shall be authorized to utilize $282,000 in funds to implement Phase 1, consisting of $220,000 for the purchase of the meters, $12,000 for the installation of the meters, and $50,000 for hardware related to this project. Section 3. The Director of Public Works, once Phase 1 is completed, shall be authorized to utilize $195,000 in funds to implement Phase 2, consisting of $175,000 for the purchase of the meters, $10,000 for the installation of the meters, and $10,000 for hardware related to this project. Section 4. All ordinances and resolutions and parts thereof in conflict with this ordinance are hereby repealed to the extent of such conflict. In the event any one or more of the provisions contained in this ordinance shall, for any reason, be held by a court of competent jurisdiction, to be invalid, illegal, or unenforceable in any respect, such invalidity, illegality, or unenforceability shall not affect the remaining provisions of this ordinance, and this ordinance shall be construed as if such invalid, illegal, or unenforceable provision or provisions had never been contained herein.
Ms. Purkeypile.
I'd like to make a motion to approve ordinance number 2212 on its first reading.
Second.
All in favor, say aye. Nope.
Discussion.
Okay.
This really isn't pertinent, but since the topic was summary of workshop and I was not at the workshop, my question is, did we ever test the water tanks?
Yes, we did.
Okay, that's all I need to know.
Yes, sir. Thank you. Ms. Schneider.
Just a handy-dandy little side note, Bull Shoals had the same problem as us. They had a whopping 27% water loss. What was ours, 90 million?
59.
They installed the same kind of new meters that we're going to be doing, and it has dropped to 2%.
Ms. Purkeypile.
I wasn't here for that meeting, and I wished I was, but could somebody just give me some bullet points, what our losses were? You said 59%?
That was the
an
difference
estimate?
between what we pay, what we collect, and what we were paying for.
okay.
That the big picture.
So did we come up with an approximate dollar amount that we'd be saving by installing these meters?
We've already saved something like $60,000 with the meters we've already put in.
The payback was in 4 years for Phase 1.
4-year payback?
Yes,
Okay.
and that's about all I remember because I've slept and I saw it.
Mr. McClung.
I just have one thing to say, and it looks like that the installation charges scare me because they're a very small portion of it's like on section in part 2 that it's a little over 5%, like 6%, but in the top one, then that's just on the in a proportion amount to the it's about that in the first section too. So that scares me.
But isn't that because we're hiring a company to do
it? It scares me that maybe they're low.
Oh, but aren't we hiring an experienced company to do this?
Mm-hmm. It'll all have to be
They
put out
know?
to bid. Yeah. So.
Good. So we will be more defined as we go along.
Yeah. This is just a preliminary. This is put together by the finance director. They can give it to me, and it's passed on.
So we can get the ball rolling.
Yes, sir.
All right.
Perfect.
I'm good.
Okay, and tying into that, so these amounts here are going to change because Mr. McClung is right that $10,000 and $12,000 is pretty low for installation. I'm assuming that the $220,000 for the purchase and $175,000 for the purchase of smaller meters. I mean, this is all going to, as you said, this will change. We'll get a bid for
It always changes.
the meters and the install. Do we think we're going to be in the ballpark?
Like I said, the finance director put these numbers together, so I'm assuming he
Okay.
feels pretty confident in that fact. too.
Following up on that your comment about putting together the numbers. So this general capital certificate account, that's a big chunk of change out of that. That I assume, Mr. Mayor, that is one of several accounts or a couple
We have
accounts.
37 accounts.
Yeah.
The city has 37 accounts, and for the
So-
breakdown, you'd have to get with Lonnie to give him all the
and
final details.
I'm going to give my little jab to the city right now. Okay, this is great. We're doing a good thing. But don't forget black bass.
Mr. Mitchell?
Yes, Dwayne had worked really hard on getting these numbers together and getting bulk purchases and the ways to bring the meters in. And Lonnie our director of finance, was very comfortable with these numbers and was also very comfortable with the fact that this would put us back in compliance with our bond issue, which was a big issue, that we were in not meeting the covenants of that, and he has already discussed with them. And one last point, and that's something. Finally, this council, other than just talking about infrastructure with this mayor and this finance director and this director of public works and attorney and everybody at this table, is actually taking action on infrastructure and not raising the individual water rates and just blowing it off and sticking it to the citizens. And that's my point.
That's a good point.
Thanks, sir. Anybody? Ms. Snyder?
I think for the purposes of the people that are watching this meeting on television, there was a story around town that it was going to be on the agenda tonight, that we were going to raise the water rates 6%. And I'd like to make it clear that that we've had meetings on this, and we have discovered and we've figured it out that if we can replace these meters and get accurate readings from them, that we should be able to recover enough of the difference in the amount of water that we buy from Boone County and the amount of water that goes through our meters, which is where the problem is. We're losing a lot of water, or the meters aren't counting it, or something is wrong here, but we're dealing with that first, and we really hope that we will not have to raise water rates at all. At least that's what we discussed.
Mr. Purkeypile.
But I do want to say, once again, rates will not be raised. However, the meters are accounting for the water more properly, so the bill
Your bill
will
might
be
go up.
Will definitely be going up eventually. The phase one for all the commercial, the large water users will go up initially, and then later on, I suspect phase two is planned, next year, this year, end of this year? When do we plan to kick this off?
I wouldn't say end of this year.
Next year?
That's very possible. yes.
Okay.
This is going to be a long, lengthy.
So expect to have your water rates increase.
And that's from
No,
usage.
your bill, not your rate.
That's from your
By city
actual
council
usage that's actually
Okay.
being billed.
Yeah,
All right.
your bill may increase, not your
Any
rate.
further on this issue? Okay. That moves us on to number, sorry.
It's a motion to approve on the first reading.
Okay. All in favor say aye.
Aye.
Any opposed? Motion carries. First reading. All right, thank you. Moves on to number 5, discussion summary workshop on yard waste. Motion to discuss.
So moved.
Second.
Floor is open.
Oh, I don't even want to do this. Really,
Oh, come on, David, jump in.
I don't.
Chicken.
I'm giving it to somebody else.
Yeah. Ms. Schneider, go ahead.
Since I've probably been working on this more. We're working on it. You know, it's about all we can say right now. It is not a plain, simple 5-minute thing. We are working on it. We are looking at a lot of options, especially in regards to what to do with vines and stuff like that, that our public works cannot deal with. I've been talking with Judge Barr in regards to burning permits, which are very regulated. He thinks there is a way that we can do this legally and have a scheduled burn so our yard people can bring their stuff in on Wednesday. Things that have to be burned, like the vines and stuff, they will have a place, someplace in town, to put that stuff, and then we can burn on a scheduled burn, as opposed to it has to be a disaster situation, which is the way, because of EPA, ADEC, and the federal government right now, we can only burn if the county judge says it's